Basic structure means fundamental principles or core values of the constitution on which our constitution is built. Basic structure means fundamental principles or core values of the constitution on which our constitution is built. The word basic structure we don't find in the Indian constitution. It was not originated from the constitution. The word basic structure we don't find in the Indian constitution, and the word is not originated from the constitution. Basic structure doctrine is a judicially evolved doctrine. Basic structure doctrine is a judicially evolved doctrine. Similar basic structure theory we also find in other countries. For example, Canada. In Canada also we have basic structure theory, which is a judicially evolved doctrine. The famous case for basic structure theory is Keshavananda Bharati versus State of Kerala, 1973. The famous case for basic structure is Keshavananda Bharati versus State of Kerala, 1973. Also called as basic structure case, also called as fundamental rights case. Keshavananda Bharati case, also called as basic structure case, also called as fundamental rights case. In prelims, if they give a question, what is fundamental rights case? It is Keshavananda Bharati case. What is basic structure theory case? It is Keshavananda Bharati case. Keshavananda Bharati versus State of Kerala. In basic structure theory, you should start your answer from Shankari Prasad case. Shankari Prasad case. There are 7 fundamental rights when the constitution was framed. Right to property is a fundamental right till 44th Amendment 1978. Till 44th Amendment 1978, right to property is a fundamental right. Shankari Prasad case deals with, can the parliament by constitutional amendment take away fundamental right? Can the parliament by constitutional amendment take away fundamental right? The Supreme Court said, fundamental rights cannot be taken away by law, but they can be taken away by constitutional amendment. In Shankari Prasad case, the Supreme Court said, law making power is different from constitutional amendment power. Law making power is a legislative power. Constitutional amendment power is a constituent power. Law making power is a legislative power. Constitutional amendment power is a constituent power. By ordinary law, the parliament cannot take away fundamental right. By ordinary law, the parliament cannot take away fundamental right. But by constitutional amendment, the parliament can take away fundamental right. The same judgment is followed in Sajjan Singh versus State of Rajasthan. The same judgment is followed in Sajjan Singh versus State of Rajasthan. That means, by amending the constitution, fundamental rights can be taken away, not by making a law. Parliament have power to amend the constitution, power to make a law. Power to make a law is called a legislative power. Power to amend the constitution is called constituent power. Parliament by using its legislative power cannot take away fundamental right. But parliament by using its constituent power can take away fundamental rights. But the judgments in Shankari Prasad, Sajjan Singh and other cases have said parliament by constitutional amendment can take away fundamental rights. Whereas in Golaknath versus State of Punjab, Golaknath versus State of Punjab 1967, the Supreme Court said, Justice particularly Subbarao, even by constitutional amendment, the parliament should not touch fundamental rights chapter. Even by constitutional amendment, the parliament should not touch fundamental rights. And then Golaknath case is very important because in this case there is a doctrine called doctrine of prospective overruling was enunciated. In this case there is a doctrine called doctrine of prospective overruling. What is prospective overruling? The judgment in Golaknath case is applicable in future cases, not in the past cases. Shankari Prasad, Sajjan Singh, all these previous cases will hold good. From Golaknath judgment onwards, Golaknath judgment will hold good. From Golaknath judgment onwards, Golaknath judgment will hold good. So, in Golaknath versus State of Punjab, the Supreme Court said, there was a judge also called, he is a judge, his name is Justice Subbarao. The Supreme Court said, even by constitutional amendment, the Parliament should not take away fundamental rights. And then what happened? The Indira Gandhi government in 1971 made 24th amendment. Through this amendment, she said, the Parliament said, through this amendment, to 24th amendment, the Parliament said, law does not mean constitutional amendment. Law does not mean constitutional amendment. They have added clause 4 to article 13 by 24th amendment. Clause 4 to article 13 by 24th amendment, and said, law does not mean constitutional amendment. Okay, that means by constitutional amendment I can do anything. Parliament said, by constitutional amendment I can take away fundamental rights. And this 24th amendment was questioned in Keshavananda Bharati versus State of Kerala 1973. This 24th amendment is questioned in Keshavananda Bharati versus State of Kerala 1973. 13 judges discussed the case. The bench constitutes of 13 judges and the judgment came out of 7:6. 7 judges said, 7 judges supported basic structure theory. What do you mean by this basic structure theory? The court said in Keshavananda Bharati case, Parliament can amend any part of the constitution, including the fundamental rights. Parliament can amend any part of the constitution, including the fundamental rights, but Parliament should not touch the basic structure of the constitution. Parliament should not touch the basic structure of the constitution. And the court also said in Keshavananda Bharati case, the power to amend the constitution does not mean the power to abrogate the constitution. Court also said the power to amend the constitution does not mean the power to abrogate the constitution. The power to protect the constitution, the power to make it dynamic does not mean the power to ransack the constitution, the power to dismantle the basic core principles of the constitution. And then the court again said, basic structure doctrine is not exhaustive but illustrative. I cannot make basic structure doctrine as a watertight compartment. Basic structure doctrine is an evolving doctrine. It's an evolving doctrine. From case by case, situation to situation, we will define the basic structure. Not by a single judgment, not by a watertight compartment, but we are trying to define that basic structure theory by case. For example, in Indira Gandhi versus Raj Narayan 1975, Indira Gandhi versus Raj Narayan 1975, rule of law, free and fair elections are considered as basic structure. Rule of law, democratic process, free and fair elections, it is considered as basic structure. The very famous case Indira Gandhi versus Raj Narayan. What is this case all about? Indira Gandhi's election was questioned in Allahabad High Court. Indira Gandhi's election was questioned in Allahabad High Court. Her opponent Raj Narayan said that she used all her official machinery, office staff to win over the elections. And after verifying all the facts, Allahabad High Court gave a judgment. This is the famous Indira Gandhi versus Raj Narayan. The court said, rule of law, you might be the Prime Minister, the other person might be the common man. Law is applicable to both of you equally. and election should be free and fair. You should not use your office for elections. Election should be free and fair. Rule of law, democratic process, free and fair elections, it is a basic structure of Indian Constitution said by the Allahabad High Court in Indira Gandhi versus Raj Narayan. In the same way, in Minerva Mills versus Union of India 1980, Minerva Mills versus Union of India 1980, judicial review is considered as basic structure. Judicial review is considered as basic structure. What is judicial review? The power of the court to verify the law made by the parliament whether it is in accordance with the principles of the constitution or not. Judiciary has the power to review the laws made by the parliament. This is basic structure. No law can take away the power of the court to judicial review the law. Judiciary have this power to review the law. This is called judicial review. And in the same case it was told, harmonious relationship between fundamental rights and directive principles is also a basic structure. In Minerva Mills versus Union of India, it was said that harmonious relation between fundamental rights and directive principles is also a basic structure. Later on, even in L. Chandrakumar versus Union of India, L. Chandrakumar versus Union of India, it was said that judicial review is a basic structure. L. Chandrakumar versus Union of India. In S.R. Bommai versus Union of India, S.R. Bommai is a very dynamic and very big case, very important case, landmark judgment in the constitutional history of independent India with respect to Article 356, President's Rule. In this case, secularism is a basic feature of Indian Constitution. Secularism means protecting and treating all religions equally. Secularism is a basic feature of Indian Constitution. Okay, whenever you are writing answer on basic structure theory, how basic structure theory got evolved, the structure of the answer is, I am repeating now, kindly follow the structure of basic structure theory. Introduction. Basic structure theory we do not find in the Indian Constitution, it was a judicial evolved doctrine. Basic structure means the core values or fundamental principles of the Constitution. The ideals and aspirations and foundations of our Constitution is called basic structure. Initially in Shankari Prasad and Sajjan Singh cases, the Parliament told, the Supreme Court told, in Shankari Prasad and Sajjan Singh cases, the Supreme Court told, Parliament have unlimited power through its amendments, can change any principle in the Constitution, can even take away fundamental rights. Parliament have unlimited powers. By amending the Constitution, it can do anything, even take away fundamental rights. In Shankari Prasad and Sajjan Singh cases. Whereas in Golaknath versus State of Punjab in 1967, the Supreme Court said, Parliament have no power to touch the fundamental rights, even by constitutional amendments. Parliament have no power to touch the fundamental rights, even by constitutional amendments. And to undo this Golaknath judgment, the then government by 24th Amendment in 1971 added clause 4 to Article 13, stating that Article 13 deals with laws inconsistent with fundamental rights are void. We should not make any law which is against fundamental rights. Article 13 says there should not be a law against fundamental rights. But clause 4 was added to Article 13, stating that law in this article does not mean constitutional amendment. That means Parliament, by amending the Constitution, can even do away with fundamental rights, can even take away the fundamental rights. This 24th Amendment and Golaknath judgment, all these things were questioned in the historic case called Keshavananda Bharati versus State of Kerala 1973. All these were questioned in the historic case called Keshavananda Bharati versus State of Kerala 1973. In this case, the Supreme Court said, basic structure of the Constitution should not be touched. You can amend any part of the Constitution, including fundamental rights, but basic structure should not be touched. And the basic structure doctrine is evolving doctrine. It is not a static doctrine. It keeps on evolving. By case, Supreme Court is protecting the core values of the Constitution. Parliamentary form of government comes under basic structure. Separation of powers comes under basic structure. Democracy comes under basic structure. Republican form of government comes under basic structure. These are all basic structures of the Constitution. And Indira Gandhi versus Raj Narayan case, rule of law and free and fair elections is considered as basic structure. Mirror Mills case, judicial review is considered as basic structure. Harmonious relationship between fundamental rights and directive principles is considered as basic structure. S.R. Bommai case, secularism is considered as basic structure. After writing all these things, last paragraph. The Indian judiciary played a dynamic role in protecting the core values of the Constitution, in protecting the basic fabric of the Constitution. From case to case by case, basic structure of the Constitution is being protected. The Parliament have no right to invade into the core values of the Constitution. The Parliament have no right to invade into the core values of the Constitution. This is how you have to write your mains answer when a question is asked on basic structure theory. Okay, done?